A 24-year-old man was stopped over unpaid tolls, and within 2 minutes he was dead. No robbery, no chase, no weapon in his hands. Now the Supreme Court, 9-0, says courts must finally look at the whole encounter, not just the instant before the shots. Quick question, are you subscribed yet? If not, hit subscribe right now, because this ruling matters the next time lights flash behind you. If you drive, if you ride with friends, or if you lawfully carry during a traffic stop, you need to hear this. For years, some courts treated deadly police encounters like they began at the very last heartbeat. They zoomed in on the final flash of danger and cut away everything that came before it. That meant the stop, the tone, the commands, the officer's choices, and the reason for the stop could all get pushed aside. The Supreme Court just said that approach was wrong, and that correction now reaches every state in the country. The case is Barnes vs. Felix, decided in May of 2025, and the vote was unanimous. That matters because this was not a narrow win squeezed out by one justice. Every member of the court, from left to right, agreed the lower courts had been using a broken lens. When 9 justices move together like that, it usually means the problem was too obvious to ignore any longer. Before I explain the rule they changed, quick question. Subscribed yet? You're going to want notifications on for this. What the court just fixed can shape how a deadly stop is judged, and most people won't know it until the worst day of their life. Here's the old problem in plain English. In several parts of the country, judges were using a shortcut that focused almost entirely on the split second when an officer claimed to feel threatened. If that final instant looked dangerous, the rest of the encounter often faded into the background. It was like watching only the last frame of a house fire and pretending the sparks, the smoke, and the bad decisions never existed. That shortcut made it much harder for families to challenge police shootings in court. Now think about what that means in real life. A person can be stopped for something minor. Voices rise, commands get rushed. Fear builds on both sides. Then one fast move happens, and under that old approach, a court could act as if the story started right there. That is why this case hit so hard. The stop in question was not for a violent offense. It began because a toll system flagged unpaid road fees. Not a felony chase, not an armed standoff, not a report of somebody attacking anyone. A man was pulled over money owed on a roadway, and what followed turned into a fatal encounter almost before it began. Back in April of 2016, a traffic officer in Harris County, Texas, stopped 24-year-old Ashton Barnes on the tollway. The officer approached and began asking routine questions. Barnes said he did not have his driver's license on him, and the car was a rental tied to his girlfriend. At some point, the officer said he smelled marijuana, and the stop started getting more tense, more controlling, and more dangerous. Barnes said he might have identification in the trunk. The officer told him to open the trunk from inside the car. To do that, Barnes turned off the ignition. Up to that point, the whole encounter had moved fast, but it had not yet turned deadly. Then the officer ordered Barnes to get out. Instead of stepping out, Barnes restarted the car. Right there, the situation changed in a serious way. But what matters now is that the Supreme Court says courts cannot judge only that moment in isolation. They must ask what led to it, what warnings were given, what choices were made, and whether the officer helped create the danger before the trigger was pulled. The officer drew his gun and moved onto the side of the vehicle as the car began to roll. He shouted commands. Then, within seconds, he fired into the car. Barnes was struck and died at the scene. He was not armed, and what began as a toll-related stop ended with a young man dead on the roadside. His mother, Janice Barnes, sued. She argued that her son's Fourth Amendment rights had been violated. That amendment protects people from unreasonable government force, which includes police using excessive force. In simple terms, the case asked whether the shooting should be judged by the full story or by only the final burst of danger. The lower courts did what several courts had been doing for years. They looked mainly at the last seconds, saw a moving car and an officer saying he was in danger, and treated that as enough. That narrow view shut the case down before a full jury could weigh everything that happened. The Supreme Court stepped in because that way of judging force had drifted too far from the Constitution and from older Supreme Court rulings. This is where the ruling becomes huge for everyday people. The court said there is no stopwatch on the Fourth Amendment. Judges are not allowed to put blinders on and pretend the beginning of the encounter does not matter. They must look at the totality of the circumstances, which is a legal phrase that simply means the whole situation from start to finish. That phrase may sound technical, but the idea is simple. What was the stop for? How serious was the suspected offense? What did the officer say? What did the person in the car do? Were the commands clear? Did the officer take steps that increased the danger? Under the new nationwide rule, all of that belongs in the picture. That change matters in a country where traffic stops are one of the most common ways regular people meet armed government power. It matters to parents driving home late. It matters to young men in rental cars. It matters to anyone who has ever felt their heart race when red and blue lights appear in the mirror. And yes, it matters to lawful gun owners too, because police encounters do not happen in a vacuum, and context can decide how your actions are judged. Let me give you a cleaner example. Suppose you get stopped over a broken tail light. You're nervous, trying to find your registration, and your hands move toward the glove box. Under the old narrow approach, a court might focus almost entirely on that reach and ask only whether the officer felt scared in that instant. Under the new rule, a court can also ask whether the stop was low level, whether the officer barked conflicting commands, whether you were trying to comply, and whether the officer escalated a simple encounter too quickly. If you lawfully carry a firearm and your state requires disclosure during a stop, context becomes even more important. A judge can now look at whether you informed the officer calmly, whether your hands stayed visible, whether the officer gave clear instructions, and whether the officer's reaction matched the actual threat. That does not erase officer safety concerns, and it does not excuse bad choices by drivers. But it does mean a court must look at the entire exchange, not just the most frightening second. Let me ask you something. If you care about your rights, hit that subscribe button. I'll wait, because the next part explains why a ruling like this can help both civilians and officers, and that's where a lot of people get lost. One reason this case drew all 9 votes is that the court had already pointed the law in this direction decades ago. Back in an earlier case called Tennessee v. Garner, the Supreme Court made clear that force cases are supposed to be judged by the whole situation. Some lower courts still drifted into a tighter, more officer-friendly shortcut. Barnes gave the justices a chance to pull the law back to where it was supposed to be. That is also why this ruling did not split along the usual political lines. Conservative justices joined liberal justices. Nobody wrote a furious dissent. Nobody defended the old shortcut as the right rule for the nation. The court treated the fix as basic constitutional housekeeping, which tells you just how far the lower courts had wandered. There was also a separate opinion that made another important point. Looking at the whole encounter does not automatically hurt police officers. Sometimes the full story can support them. If an officer gave calm warnings, faced a real threat, and had little time to respond, the broader context may show the force was reasonable. So this ruling is not a one-way weapon. It is a demand for honesty about what really happened. That matters because public trust collapses when courts seem to crop the story to protect one side. If people believe judges only examine the last flash of motion, they stop believing the system is serious about truth. A full context rule does not guarantee the result any family wants, but it does force the law to face the entire chain of events. That alone is a major shift. It also ends a quiet unfairness that existed across the map. Before this ruling, your odds in a force case could change depending on where you lived. Some federal courts were more willing to review the full encounter, while others were more likely to narrow everything down to the last instant. The Constitution is not supposed to work like that. Your rights should not shrink because you crossed a state line. Now picture the practical side of this for someone watching at home. You may never file a civil rights lawsuit. You may never set foot in federal court, but you still live under the culture those rulings create. When courts examine the whole encounter, police departments feel pressure to train for de-escalation earlier, to give clearer commands, and to avoid tactics that turn a minor stop into a deadly one. That is why Barnes matters even beyond this single family. A ruling like this can shape future training manuals, future internal reviews, and future courtroom decisions. It tells departments that the lead-up counts. It tells officers that jumping from tension to deadly force will not be judged in a vacuum. And it tells families that the full story cannot be legally erased just because the final second looked frightening. For responsible gun owners, this is worth paying attention to without turning it into something it is not. Barnes is not a Second Amendment case, and it does not create a new carry right. But if you keep a firearm in your car, transport one to the range, or disclose lawful possession during a stop, you know how fast ordinary traffic encounters can become high stress. A rule that requires courts to study the entire exchange matters to you because context matters to survival. The details before the trigger matter more than most people realize. Tone matters. Whether the officer approached with calm or aggression matters. Whether commands were clear or confusing matters. Whether the officer stepped into danger when there were safer options matters. The Supreme Court just said none of that can be brushed aside anymore. Here's something crazy. 87% of people watching right now aren't subscribed. Don't be part of that statistic. If you want plain English breakdowns of rulings that could affect a traffic stop, a police encounter, or how your rights get judged in court, subscribe now because most people hear about this stuff only after the damage is done. There's another part of this story that keeps the victory from being too easy. The Supreme Court did not say, once and for all, that the officer in Barnes violated the Constitution. Instead, the justices sent the case back down so the lower court could review it again using the right standard. In legal terms, that is called a remand. In human terms, it means the family gets another chance to be heard under the proper rule. That second chance matters. Nearly a decade passed while the old framework blocked a fuller review. Think about that delay for a mother who lost her son. Think about what it means to hear that the law used on your case was not the right one. The ruling cannot give time back, and it cannot undo the death, but it can reopen the door that had been slammed shut. Still, there is a hard truth people need to understand. Even with this ruling, police accountability cases remain difficult. One major reason is qualified immunity, a legal shield that often protects officers from being sued unless a court says they violated a clearly established right. That is a separate hurdle, and it can stop a case even after a family proves the force looked unreasonable. So Barnes is not a magic wand. It does not suddenly make every bad shooting easy to challenge. What it does is fix the first lens the court must use. Before, some courts were beginning with a cropped image. Now they must start with the full frame. That is not everything, but it is not small either. In law, the first question often shapes every question after it. For ordinary people, the lesson is not to become paranoid. It is to understand how much the record of an encounter matters. The reason for the stop matters. What was said matters. Whether commands were heard and understood matters. What happened before the final burst of fear matters. If the worst happens, those details are no longer supposed to be swept off the table in large parts of the country. It also means public discussion needs to get smarter. Too many people hear about a shooting and rush straight to the final second. They ask what the officer saw right before the shot, or what the driver did in the instant before impact. Those are fair questions, but they are not the only questions. Barnes reminds the country that truth lives in the full sequence, not just the climax, and that full sequence approach is healthier for everyone. It is better for citizens because it stops courts from ignoring bad escalation. It is better for good officers because it allows them to show the real threat they faced over the whole encounter, not just through a frozen frame. It is better for judges because it keeps the law tied to real life instead of a legal shortcut that hides half the story. If you are the kind of person who keeps documents organized in the car, who tries to stay calm during stops, who teaches your kids to keep their hands visible and answer clearly, this ruling speaks directly to the world you live in. It says those facts are not side notes. They are part of the constitutional picture. The law is finally admitting that roadside encounters do not begin at the trigger. The same goes for communities that have spent years feeling like no one wanted to hear the whole story. Barnes does not promise perfect justice. But it does say the legal system cannot act like the first 90 seconds of a stop are invisible. When power ends a life, the courts owe the public more than a snapshot. They owe the full chain of events. That is the deeper reason this 9-0 ruling matters so much. It restores a basic rule of fairness. If the government takes a life, judges must examine everything that led there. The stop, the commands, the fear, the choices, the escalation. The final shot cannot be ripped out of the story and treated as the whole truth. So bring this back to yourself for a second. The next time you see flashing lights in the mirror, you are not thinking about Supreme Court doctrine. You are thinking about your hands, your voice, your passengers, your documents, maybe even the lawful firearm locked away in your vehicle. Barnes matters because it says the law must care about that whole moment, not just the instant when things go wrong. And that should matter to every American, whether you love police, distrust police, own guns, hate guns, or never think about any of this until it lands in the news. A constitutional right is not just words in a textbook. It is the standard used when the state uses force against a real person on a real road. If the standard is too narrow, the right becomes paper thin. The Supreme Court just said that paper thin version is not good enough. The whole encounter must be judged. The whole story must be heard. The whole chain of choices must be examined. For years, some courts let that duty slip away. Now the rule is back, and the personal stake is simple. When power meets your life on the side of the road, every second leading up to that moment is supposed to count.